My lady Washika.
Who is starting? Is it you or?
I'm starting.
Okay, starting the process. Washika.
Yes. My lady, we presented an application dated the 24th of January 2017. 24th of January 2017. My lady, the application seeks, indeed, not to be repetitive, but the application seeks a review of your orders of the 12th of January 2017. The orders were to the effect of sentencing the contemners to a 1-month suspended sentence. My lady, the application is supported by the affidavit of Dr. Frederick Ouma Oluga, who is the National Secretary or Secretary General for the Union. My lady, your directions before. Yes. Ouma Oluga, Frederick Ouma Oluga. My lady, your directions before we took a brief recess was that we demonstrate attempts that have been made by the parties to call off the strike or resolve this issue. We have annexed indeed to our affidavit minutes of a meeting, a consultative meeting between the stakeholders, being the Ministry of Health and the union, the Kenya Medical Practitioners, Pharmacists and Dentists Union. The said meeting was on the 17th of January 2017. In attendance, my lady, were the Cabinet Secretary who chaired the meeting, Dr. Cleopa Maili. As co-chair in that meeting was the chairman of the union, Dr. Samuel Oroko. My lady, from that, from the minutes of that particular meeting, if my lady would have an opportunity to observe, on the first page, the application was filed on the 25th of January.
25th of January?
And the certificate of urgency.
24th or 25th? 24th?
The application is dated 24th, but it was filed on the 25th. It was filed on the 24th, sorry, I apologize. 24th.
Yes.
So on the face of that annexure, F01, already we have pointed out, or it is presented on the face of that, of those minutes, the agenda of that meeting. My lady, you note that the agenda of that meeting is in compliance with the orders of Justice Abuoza of the 1st of December 2016, wherein he directed that these parties proceed and discuss the body of the CBA. Now, my lady, you note that that is the main agenda.
Orders of Justice
Abuoza, your brother Justice Abuoza of the 1st of December 2016. Sorry, my lady. The order was to the effect that parties proceed and discuss the body of the CBA, which indeed is the agenda of that meeting.
Mr. Washika, I have the court file here with me.
Yes.
And please be candid with this court and tell the court only the truth.
Yes.
And nothing but the truth. I have the file.
Yes.
So these are the orders of Justice Zabora on 1st of December. The strike notice issued on 14th November 2015 is hereby suspended for 30 days. Prayer number 5 is hereby granted as well. The respondent will be served with the application. Prayer number 5. So I want you to refer to the document that you are talking about as you address this court.
Yes, my lady, I'm referring to the order of 1st December. The order was issued on the 2nd of December from the copy of the order, but it was an order of the 1st of December.
Yeah.
Issued on the 2nd of December. My lady, if you look at the orders that were granted to the Council of Governors in this matter, 2486 of 2016, the order number 3 reads that this Honorable Court hereby directs that the district be subjected to an inclusive process of negotiations to resolve any outstanding issues arising from the collective bargaining agreement dated 27th June 2016 in such a manner and within such timelines as this Honorable Court will direct.
Let's go on.
That is the order of 1st December, but issued on the 2nd in the lead. And that is the order that...
that is order number 3.
Yes, that is
order number 1 and 2 also.
Yes, but we are demonstrating our compliance with that particular direction of negotiating with the parties.
Okay.
So, my lady, indeed, the parties did proceed from those minutes to break down or to sort of unpack that CBA in compliance with that order, and proceeded to examine the CBA point by point, and it is captured, or article by article as it were, and it is captured in those minutes. My lady, we submit that this was in pursuant to your direction to resolve the issues as was granted, the directions you gave when you suspended, the first time you suspended the sentence. My lady, you directed that parties proceed and attempt to finalize on these issues within the period that you have initially granted, the 14 days. My lady, we've also been tasked, or you have directed that to demonstrate what other attempts have been made by the union to call off the strike. And before we proceed into that, we also wish to point out that the issue of the process of negotiations, or to try to resolve this stalemate as it were, directed by the court order of Justice Zabora, and my lady, when you issued the suspended notice, for that to happen, both parties must engage, or both concerned parties must be part of that process. It cannot be a one-sided process. With that regard, this order has been sought by the Council of Governors, which, my lady, we submit at no particular point during the entire period of the suspended sentence have they engaged, or were they ever willing to engage with the union. My lady, there has been no demonstration at all before this court in terms of the responses that have been filed that demonstrate that the Council of Governors has indeed, in any particular instance, sought or attempted to resolve the matter in compliance with the order. it will be a difficult position for one party to proceed and attempt to negotiate on its own. It requires goodwill from both sides. This order was sought by the Council of Government. But apart from that, my lady, there have been several meetings, both publicly and informal, in terms of attempts at lobbying that have been done by the union. Particularly, my lady, on the 17th of January, on the 28th of January this year, my lady, on the 16th of January, where the Ministry of Health officials, before this meeting that the minutes have been annexed, was called for. It was part of that meeting, setting the ground rules. My lady, also on the 23rd and 24th of January, attempts have been made to resolve this stalemate. My lady, even internally within the union itself, last week after your orders on Thursday, the union did proceed to have an annual general meeting with its members in an attempt to get the mandate as directed in the union's constitution to call off that strike. My lady, that AGM required a process of balloting, which did not result in a vote to call off that strike, my lady. My lady, in another attempt to resolve the issue, the National Executive Council of the Union did meet this past Saturday to deliberate on the same issue, which also did not culminate in the calling off of that strike. My lady, further, just to demonstrate the extent that parties are engaging, the union this morning presented a petition to the Parliamentary Committee on Health. They have been called for a meeting today with regard to that particular petition. My lady, they also have a meeting scheduled today with the Salaries and Remuneration Commission on the same issue that are before this court. My lady, we submit that a further suspension of your sentence would ease or bring to a quick resolve of the issues before this court. My lady, if you decide on the contrary, the effect would be that the union now lacks leadership for further 30 days, which would result in further loss of time between the parties to resolve the issues. Lady, undoubtedly, to my mind, it also result into the unfortunate loss of goodwill between the parties to resolve this matter. Based on the submissions I have made, my lady, I conclude by saying, on our client's part, it is apparent that the other parties are not engaging in honesty. We would request there is a request indeed, my lady, to this court that based on the directions of Justice Abuoza on timelines, because he also inferred on timelines for negotiations, which timelines were not provided, my lady would request for timelines to be met, or to be given, and timelines for them to be met. Will this court direct negotiations to be structured either by appointing a mediator who is agreeable to all parties and giving guidelines as indicated in that order on when or how the talks should be structured, who sits at the table, and those things that will enable parties to quickly reach a resolve. My lady, I rest. If counsel should start.
Thank you. I'll just start.
Now that you have taken 10 minutes, can you take 3 minutes?
I'll be brief. My lady, in reference to your order, paragraph 14, which reads, the order of the court was to stop the strike in strictly, and the excuse of the respondent cannot withstand it. This court finds the respondent and its officials are guilty of contempt of this court order the 1st of December 2016 and must be punished. My lady, in fact, this court has issued 2 orders. The order in 2486 and 2479, which has been consolidated.
24? 2 files?
The suit filed by Moi Teaching Referral Hospital has an order on the same day. And this is my view, my lady, in an attempt to persuade you to review your order. The court suspended the strike for 30 days but issued yet another direction. That is the portion, my lady, I would plead with you today to issue directions and review your order. This court hereby directs that the dispute be subjected to an inclusive process of negotiations to resolve any outstanding issues within such guidelines as this court may direct. I've looked at all the orders issued subsequently. No such directions have been offered. And let me tell you, because I've been this official have entrusted me to be their Kofi Annan, so I've been doing the shuttle diplomacy between them.
Which document are you referring? Is it a judgment or a ruling?
Order.
The order of which date?
Of 1st December. There are 2 orders.
Okay, you're referring to the order.
Yes. I'm simply saying that in my shuttle diplomacy between the officials and the cabinet secretary, the frustration has been that there does not appear to be something that will make the other party on the other side sit on the table and agree. And the reason is that had you issued guidelines and timelines so that the doctors cease their strike and the ministry then completes these negotiations as proposed in this order, my lady, maybe we will not be here. The second order issued in favor of Moi Teaching and Referral, my lady, is also instructive. It says the court suspends the 30-day strike issued on 14th November and directs the parties to go through a conciliation process under the auspices of the Cabinet Secretary, Labour and Social Security Staff. I am not aware to date of the presence of that Cabinet Secretary either in these proceedings or any negotiation. But my lady, the union officials still have the contempt of part of the order on their head. Yet that Cabinet Secretary referred to in this order has not been requested by this court to give a report or a direction as to what they have done. So, in reviewing your order, because the contempt is based on the order of 1st of December, and since, and I've said this before, that you have a wide discretion, you can review the sentence and even the suspension, both, so that the person sitting in Apia House this morning and possibly watching these proceedings on TV, and the other person sitting in the NSSF building, Cabinet Secretary Social Services, my lady, can present a report to you. I am glad, and I must say this, I was very happy that you offered last week that had these parties directed you to assist them, you would have. And the assistance you can offer them, my lady, It's not jailing them, because you have already issued the sentence. It's directing the persons responsible to be able to provide this court, as ordered here, with what they have done to make sure that these officials and doctors all over the country go back to work. That, my lady, would be justice to everybody. So that we can put all this, everybody's direction, so that even my lady, C.S. Maidu, can know that he can be in contempt, Rachel Omamo can be in contempt, or Kandia, because you have issued a order. Because this one appears as if only one person is supposed to look for, make sure that this ends. And therefore, this is not a happy day to stand here and think that these ladies and gentlemen will go to jail. It's not a happy day. But I know, my lady, that you can offer, just like you did, a direction. Because the orders are existing, they have not been overturned, they have not been appealed from, you can offer that direction. And that way we will not be negotiating with the cabinet secretary with cards under the table, because this court has issued that order. Lastly, the persons who sought this order, the Council of Government, have not even bothered even to call for a meeting. All they want is these officials to be there.
I'm not called for?
A meeting. Just a meeting, even if it was a cup of tea. It's not called for any meeting. The person to whom this order is in favor of have not even bothered to call for a meeting. I don't want to sound pessimistic, but my lady, I think it's time you issued a proper direction. The person who got the order has not taken action. The persons who ought to be directed, Cabinet Secretary Health, Cabinet Secretary Social Services, under this order are sitting pretty. And the doctors, my lady, are out in the streets blowing whistles. And these ones are preparing to go to jail. It's not fair. I plead with you.
Okay, we'll move to the other side. Can I see the councils addressing me, please? I can't see them. I can't see them. Okay. So we start with Ms. Milo?
Ms. Milo.
Yes, Milo.
For the interested party. The application is the cost. We have filed our ground of opposition dated 30th January. And we have also filed our telephone submission this morning, dated 30th January. And my lady will wish to proceed to make the application. My lady, it's our annual submission that the application does not meet the threshold for review set out under Section 15 of the Employment and Labor Relations Act and Rule 33 of the Employment and Labor Relations Rule 2016.
Rule 32?
Rule 33. My lady, the grounds for review are very clear. And my lady, you are not being told to review the orders because the applicants have discovered any new evidence or there is any mistake or error apparent on the record or the judgment requires clarification. My lady, the court orders were very clear and the applicants were found to be in contempt of court. Up to date, they have not passed that contempt. And my lady, actually they do not have a right of audience before this court. My lady, our second ground is that the application cannot meet the threshold for review because, my lady, under Rule 33, you can only review if you have not appealed. And it is very clear. My lady, the applicants have already filed an appeal, being appeal number 9 of 2017.
That's right.
And filed on 17th January.
Just a minute. You say They have filed an appeal?
They have filed an appeal, both to the orders of
Appeal number?
Appeal number 9 of 2017, filed on 17th January 2017. And my lady, in the appeal, they are challenging the orders of this court of 12th January. And my lady, in that regard, don't call this a forum shopping, because they are already in the two courts and the two applications cannot be done at the same time. You can only pursue one. And my lady, we are relying on the authority of William Karani and 47 others, versus Michael Wamalwa Kijana. It's a Nakuru Court of Appeal 43 of 1986.
Michael Wamalwa Kijana, Nakuru?
Court of Appeal number 153 of 1986, my lady. It's reported, my lady. And my lady, if I can read.
The authority has been submitted. It is on the file. Yeah, you can read.
My lady, the judge was referring to section 80 and order 45 of the Court of Appeal rules, where it says is a means of airing gross or obvious errors while looking at review, when an appeal is allowed by the act from a decree or order, but no appeal has been deferred. And secondly, in cases where an appeal is allowed at all, the court said that you cannot exercise both. You can only pursue one. So, my lady, the application before this court is an abuse of the court process, and the applicants have not demonstrated why they are abusing the court process. My lady, the applicants have come to this court with unclean hands, and they need not to be there by this court. My lady, further, the applicants are seeking an order in the application order 5, that the court issue an order against the Council of Governors and the Cabinet Secretary, Ministry of Health, not to frustrate further negotiations on the subject matter and promptly call and attend all negotiation meetings. My lady, the court cannot be called upon to issue such orders because no evidence has been brought before this court to demonstrate that the parties whose orders are being sought against have frustrated the negotiations, my lady. You have only been issued with an annexed F01, which only demonstrates some meetings which was being conducted. And actually, you will confirm that the Cabinet Secretary was chairing the meeting. So, my lady, the court cannot be called to issue such orders which are uncalled for when there is no evidence brought before this court to demonstrate that. My lady, the last issue is on the application of the Contempt of Court Act 2016. My lady, you will appreciate that the court issued its orders on 12th January, where it found the applicants in contempt and sentenced them. My lady, the act came into effect on 13th January, and it is an argument that such an act does not apply in this matter and cannot apply retrospectively. The law does not apply retrospectively unless stated in the law. It is our humble submission that, my lady, the application is actually or dismissed with cause. My lady, we urge this court to stand strong and be firm on its orders and ensure the orders are enforced to the tail end. My lady, the orders by Justice Abola of 1st December was an order that the strike notice is suspended. My lady, such an order has not been complied with up to date, and the issues are over 2 months. My lady, the court orders were very clear and they did not need any further clarification. It is our argument that the application be dismissed. Since the applicants before the court, they have not shown any remorse or even are not ready to call off the strike. And they are not demonstrating why they are not calling off the strike they need. They cannot be in this court and they should be put for being in contempt. These are my submissions, my dear.
Mr. Till, are you going to be speaking? Also, you are done. Will I stop for you? I want to see the council, please. These two gentlemen stand in front of me. I can't see the council. So, yes.
Lady, the applicants have requested for mediator.
Yes, yes.
My lady, this is not called.
They have called for a mediator?
In their submissions, the oral submissions before this court, they made the oral submissions and requested for mediator. My lady, this is an order. It was not the application. My lady, the first thing they should do before they ask to call for mediator is to call off the strike. My lady, justice needs to be seen, not heard. And this court needs to speak loudly. Kenyans are suffering out there. Let the court do it.
Assessor Mamala, who goes first?
Thank you, Your Honor. Just to begin with, as earlier explained, we had filed a notice of grounds of opposition because we are opposed to their application. Now, just before I proceed, I would like it to be clear that the Council of Governors is not on trial before this court. The Council of Governors bears no burden of proof. We are not. My client is not on trial. My client bears no burden of proof, and therefore does not have to stand here to try and prove anything. The burden is not borne by my client. And as I seek to argue my application, Your Honor, I'd like to say that the conduct of doctors and the continuing contempt has allowed us to peer into the hearts of the people that have sworn to really look after our affairs and the sick people of this country. And what we have seen, my lady, is such lack of mercy and callousness that has shocked the nation. I don't know about you, but for me, my lady, if I was at the operating table and one of these officials feared with a scalpel, I would take to the... I would run, I would literally run away because of what has been demonstrated. Now, now it was argued by Mr. Washika, for the respondent applicant in this application, that the Council of Governors, he argued this on the 12th of January, came before this court because of a document he refers to as a CBA. Now that is not the reason why the Council of Governors came to this court. On the 1st of December last year, 2016, the Council of Governors approached this court, and this is the issue we need to focus on, not sideshows. The Council of Governors approached this honorable court because there was an impending strike action. And who was the party? The party intending to strike was a party offering essential services. Essential services, as outlined in the Labor Relations Act, Section 81, is a service where strike is not something that it should just be declared and handled casually by the officials. And they have done that this time. It's an essential service, well spelled out under Schedule 4. And we were apprehensive, my client was apprehensive of the magnitude of suffering that would occur and that we have seen occurring over 57 days on. So that is why we came to court, and the court listened to us and looked at the documents we placed before it, and indeed on the 2nd of December we received orders. And what were the orders? Because, my lady, when you look at the application by the respondents, they are being very dodgy in how they are making their arguments. Why? Look at even what they have written in the application. The certificate of urgency, the third paragraph, they are telling this honorable court that the first to 8 respondents applicants have to their best complied with the directions of this honorable court of further engaging with the claimant respondents. But my lady, where is it written that we must obey certain orders and not others? The court orders were very specific. Our application was certified urgent, that was one. Number 2, the strike notice issued on 14th November 2016 was suspended for 30 days. Those 30 days were a beautiful window within which these officials would have demonstrated good faith. And how do they do that? By putting in place mechanism, even if it's a mediator you wanted. And maybe that's also, they talked about a mediator here. And I heard that they requested for mediation. But what is worrying me is the level of lack of understanding of basic concepts like mediation. How would someone say genuinely that they are seeking mediation and then they are saying mediation in the full glare of the media? Is that the practice of mediation? Is that really the practice of where? I think it's just getting the euphoria and getting into the limelight and wanting to be martyrs without a cause that is going on here. Because mediation is not possible. It's a private and confidential arrangement where parties are able to negotiate freely and in good faith. That they would have done within the 30 days, which they failed to even demonstrate. They would even have pretended perhaps for the 30 days and then come to court and say we have tried. But they cannot say we are obeying this order and then if we don't feel like obeying that order, we will not. Remember, my lady, your directions in terms of the principles of contempt as outlined in the various laws. When you look at the ruling of 20th December, it was very clear that it is essential for the maintenance of the rule of law and order that the authority and dignity of this court be upheld at this time. And that order is so uncompromising in nature that it extends to cases where persons affected by an order believe it to be irregular or void or wrong. You obey it, and then through your counsel you come to court and ventilate the issue. The work of industrial relations court is to maintain the various relations. There are various parties here. It is not only about your party. The Council of Governors has employed over 80% of the respondents, past respondents. Their employees, over 80%, are employed by the Council of Governors. Okay? Now, in terms of the order, what we are also saying is that it's frivolous and vexatious. Why are we saying this? Something that is frivolous is insufficient on the face of it. When you look at their application, without more, on the face of it, it is not only insufficient, it raises no triable issues, it is basically it's what failed me, but basically there's nothing, it has very little weight, okay, to sway this court. And secondly, it's vexatious. In law, when something is vexatious, my lady, it means that it lacks good faith. It's vexatious because it lacks good faith. It is intended to annoy, to embarrass, and has no specific practical result. What is the specific practical calculated result of any review, my lady, of any extended suspension? Nothing. It's not there. Okay? Then let's go to the issue of concurrent jurisdiction. The jurisdiction of the Court of Appeal to hear a matter that is also allowable by the labor and industrial relations court, like the current application. Now, when you have concurrent jurisdiction, what you need to do is to elect where to take your case for review. You can either elect to go to the Court of Appeal or elect to go to the court that heard you for review. Now, you cannot take the matters in both courts. Why is that so? Because if the other court issues an order and it's contradictory with the other order, I'm just trying to explain it the best way possible, my lady, then it's a contradiction. They elected to go to the Court of Appeal, not once, they have gone twice now. They are here as well. This is without more abuse of the process of this honorable court. Up to date, there is no indication or demonstration as to why the court orders stopping the strike action to allow for further negotiation or for negotiations or even for appreciation of the issues by this honorable court has been put before the court. There is no stay order staying your order, my lady, or any orders that you've made in this matter. The issue of contempt of court is a question which is best dealt by this honorable court, my lady, as I earlier stated. Only this court knows how best to deal with those who are obeying it with impunity, disobeying it with impunity. Now the issue of, and this is my final submission, the issue of clean hands. We all agreed that the power to review an order is discretionary. Okay, it's within the authority and discretion of yourself, my lady. And last time, when you tried to explain the concept of dirty hands, clean hands, I thought that is the same way I would explain to someone who is not a legal practitioner. And it was really in good faith. The doctors, and we are all looking forward to the day when Kenya will pay our beloved doctors very well, only comparable to maybe the best countries that pay doctors in this world, in all honesty, and where healthcare will be free. But these are political issues with political answers, and not why we were in court. When you try to explain the issue of good faith, that is, of dirty hands, the equitable principle of coming before the honorable court, seeking equitable solution or equitable remedy with clean hands, and you gave the example of how dirty hands can be, maybe a sewage. I think it was taken out of context, and they went outside and they blew it out of proportion. But that's not the only way. The only time they have taken things out.
My lady, counsel is not responding to the application. I am.
I'm explaining the issue of clean hands. You are seeking review orders. And review orders is all about, it's an equitable remedy. I don't know, my lady. Isn't it? So basically the issue of clean hands, I think my fellow counsel should just take it easy. The issue of clean hands is well explained. That is, you have to demonstrate good faith. But we have seen daily demonstration of bad faith by those who are seeking your goodness to review orders to their advantage. And how have we seen the bad faith? They have failed to call off the strike. They have used abusive language in the in the open glare of the media. They have even demonstrated, my ladies, a lack of appreciation of their responsibility as leaders of the union, and have accused their members of holding them at ransom. So, my ladies, how do we treat their application? In my view, having submitted that, their application lacks any merit. It is an abuse of the court process. It is lacking in merit, and it needs to be dismissed. Not just dismissed, my lady, but dismissed with court. Because we are aware that the union is able to pay the cost of this court. So that is our humble submission, that your orders be enforced today and that you're able to dismiss the application with court. That's all, my lord.
Professor?
Yes, Your Lordship, I have filed my grounds of provision dated 31st of January this year. In that grounds of provision, I have attached two authorities. For one, civil case number 242 of
Civil appeal or civil appeal?
civil case number 242 of 2013. 242 of 2013. That is International Limited versus Joseph Makenge Kudo.
International Limited versus Joseph?
That's International Limited versus Joseph Makenge Kudo. The other one, Your Lordship, is civil case number 69 of 2015. Sam Nyemwea and others versus Kenya Premier League Limited and others. My lady. These two authorities deals with the issue of contempt of court. And traditionally, what the courts have done to condemn us. Your Lordship, what is before Your Lordship this morning is an application to review orders that you issued. I have looked at that application. I have not seen any ground to review the order. Lordship, today we are not talking about negotiations. That is not what is before your Lordship. Lordship, very specific. What is before your Lordship is contempt of court. That is the final. We cannot look elsewhere. Why are we saying so? Because what is on trial is the supremacy of the law. That is what is on trial. And my lady, if I may quote the Chief Justice of the United States of America, as early as 1778, when he was dealing with the issue of contempt, that question, this was what was in his mind. Since, however, the question seems to resolve itself into this, whether you should fend to the law that's condemning us, or the law shall fend to you. And the answer was that the first one applies. The law, you shall bend to the law. The law cannot bend to you. You shall bend to the law. And this court is vested with very wide powers to assert the traditional and its role as it has been in the Commonwealth, that if an order has been issued by a court of competent jurisdiction, this order was not issued by the High Court or the subordinate court or the Court of Appeal or the Carry Court. This court issued the orders related to employment and labor issues. So it's a competent court of jurisdiction. And therefore, the court cannot negotiate with the person directed to obey the order, whether today you will obey it or I give you until tomorrow to see if you can obey it. This has been the trend. And the trend, for that reason, was because this court was alive to the fact that it was dealing with an industrial relations issue. But, there is an end to every process. The process that we started before your lordship obtaining the order and commencing the contempt of court proceedings and the sentence and the suspension of that sentence must come to an end. Why? Litigation must come to an end. We must close the file. We must move on to something else. We are not going to negotiate, or the court is not going to negotiate whether you can obey or not. But that is undermining the supremacy of the law. And it's the supremacy of the law that is on trial. It is not actually even the contemners. The contemners are not on trial here. It is the supremacy of the law. Whether that law can be obeyed once an order has been ordered by the judge of a competent jurisdiction, whether it can be obeyed or not. Your Lordship, looking at that application that is seeking now the review of the orders, before I proceed further, you've been directed to an annexure in that application that parties have been negotiating. Two things, my lady, come into mind. One is the date when they purported to meet, 17th of January. Long after this court has given orders that they should call off the strike. We are not dealing with technicalities here now. We are dealing with the pure position of the law and what should happen. Secondly, looking at that annexure, it is not even signed, Your Lordship. If it is not signed, I cannot hold anybody accountable to that document. Why am I saying so, Your Lordship? I humbly go back to my submission, to the submission by my colleague, Mr. Mutula, that parties have never met and the respondent has never. While my colleague is saying parties met. So basically it means that then parties have never met. So that document is not. And the other issue, Your Lordship, is that we must distance ourselves from dragging the respondents, the applicants, that is the multi-teaching referral and the Council of Governors, into the trial of the contempt of court proceedings. It is not begged, and the order was not for the multi-teaching referral to comply with the calling of the strike. That is the issue that is here. Politics aside, and we are not going now to talk about politics. We are going to be very strict to the law and say this order is directed against who. My colleagues cannot now bring in the issue of that respondents have not complied with the order. And this order was directed to the contemners, and it was their duty as the citizens of this country and who are consumers of justice from this court, because they have filed a case in this court, that they should obey the order. And if they don't obey the election, what happens is the law takes its course. The law does not discriminate. It applies equally across the board. And therefore, my colleagues who have now disobeyed that order, it means tomorrow, if I come before your lordship, obtain an order, I serve it upon somebody else, this is a precedent that court orders are not obeyed, and they incite. So, it's now upon the court to tell us, or the contemners, to tell us the change of jurisprudence, and when it changed, and when the law changed, to say that you can bargain with the court when it comes to obeying the orders of the court. Orders of the court, whether obtained irregularly, regularly, you must obey first, discharge it, or vary the orders. But compliance is not something that we bargain. And your lordship, that is very well captured in my second authority, in course number 69 of 2015. The last bit of it. And that is as per Romeo, the Lord Justice. It's plain and unqualified obligation That is what the Lords of England, the highest court, have decided. That's what they have said. They have given us those guidelines. Plain and unqualified. My lady, this qualification of partial compliance of an order of a court is not an excuse and is not an argument that can sustain the threshold to say, vary the orders now. Your Lordship, as you retire to make your ruling, or maybe you make a ruling right now, we are very much ready to get the ruling. You look at those authorities and look at the supremacy of the law as we speak now, and what precedent are we setting as a court, as an advocate of this court? Because in one of the authorities, your Lordship, you will see that in compliance of a court order, even when your advocate is aware of that court order and he has appeared before the court, the person who is supposed to comply must comply. You cannot say, I have not been served personally. That practice is not there. That is what the authority said. My colleagues came to court and they were aware of those court orders. And as an obligation of an advocate of this court is that the process is very simple. One, you tell the clients to comply, you make an application to vary the orders, then you go back to whatever that you were doing. That is the process, and that's the rule of law. Because if the rule of law is on trial at this particular time, that we cannot use that process, then, my lady, we are left without any protection.
Can you wind up, please?
Yes, Your Lordship. I want to wind up. Your Lordship, it is my humble submission that this application, in as much as they have been given a right to be heard, actually they didn't have a right of audit. But because every person is entitled to be heard, they have been heard. My submission that this application should not be allowed, and the same as my colleague had suggested, should be dismissed with costs. Let's move to the other process. Let's move from this process of contempt of court. The other processes that will follow, those are not the issues here today, and we cannot talk about them now. Even the roadmap my colleague was talking about, that roadmap, the time is gone. If you squander your time, don't come and say, give me more time. My lady, and I know very well, and you have also indicated the same, that the issue before your Lordship is about the contempt, and I fully, your Lordship, agree with your directions, that is what we should be concentrating ourselves in our argument. Therefore, my lady, I humbly suggest, pray that this application not to be allowed, and let the contemners start serving their sentence now. And the next process, my ladyship, after they're out of jail, if they want to talk, my lady, the doors are open. But for now, it is about the court, the supremacy of the law, and the rule of law. Those three things are on trial now. Thank you, Lordship, for your time.
I'll give the applicants a rejoinder. How many minutes?
Maybe 5 minutes.
Consolidated?
10 minutes, my lady.
Consolidated 10.
Much.
Mr. Cheng.
My lady, indeed, when we came in the morning, we humbly begged that you allow us to address you on this particular issues of review, and the court rightly gave us audience. And therefore, my lady, we are indeed addressing you rightfully. And therefore, because my lady, you gave us audience to address you. My lady, the order of 12th January 2017 intimated that we proceed and attempt to negotiate this particular matter. And indeed, my lady, we have demonstrated our attempt to proceed and negotiate in this matter so as we can close it. We have demonstrated that the claimants have not been willing to negotiate this particular matter, and in particular the Council of Governors. Although, my lady, we shall raise this particular issue later on, you will notice that the Council of Governors has not employed a single doctor.
Your Lordship, I kindly, with due respect, an advocate must file an affidavit to fact. That's not a legal issue, and it should be responding to the legal issues level. Factual issues that requires us to respond. I think that is not the proper process. There is no evidence that the Council of Governors are waiting the referral have abused. My colleague has said that line, my lady, should not be even captured in the record. That is a very wrong approach.
You're opening a can of worms.
Indeed, yes, that is
so
true.
let's not go in that direction.
So, my lady, the order of 12th of January was intimating to parties to proceed and attempt to negotiate. The respondents have indeed indicated the length at which they have attempted to negotiate this particular matter and close this particular file. My lady, on the issue of review, we have definitely demonstrated that pursuant to your order of 12th of January 2017 to proceed for negotiations, that indeed the respondents have attempted and attended at least 6 meetings in an attempt to resolve this particular stalemate. That particular fact, my lady, has not been disputed absolutely. And no affidavit, my lady, was filed to controvert that particular fact. My lord, my lady, again, on the issue of review, what the law restricts is when a party is prosecuting his application simultaneously in the High Court and in the Court of Appeal. That is not the case in this matter. What the respondents have asked, my lady, is a review of the orders of 12th of January 2017. That issue is not before the Court of Appeal. My lady, when you retire and look at the content of Court Act, this is the act that now governs contempt. My lady, you look at section 36, section 38, 39 and 40, which now deletes. In fact, section 30 says the Judicature Act is amended by deleting section 5. And by virtue of the fact that this act commenced on 13th of January 2017, therefore it is the proper law to be used in this particular court. Lastly, my lady, when you retire to write the ruling, you will look at the relief sought by the claimant in this particular matter. And my lady, looking at the order of 1st of December 2016, you'll find that, my lady, we are talking of an issue of a collective bargaining agreement. And pursuant to the order of 12th January 2017, those are the issues that have been discussed in various meetings that we have just mentioned. And therefore, my lady, it will be in order if we proceed and review the orders of 12th of January 2017 in order to just give a chance towards resolving the settlement. I know we are at an advanced stage on negotiating this particular matter, and I humbly beg that the orders be granted. My lady, just lastly, you will carefully look at the proceedings that were filed in this particular court. It is important that I mention this, that on 2nd of December, the party who came to court was the Council of Governors. On the 5th of December, that party amended their documents to bring in a party, the Council of County Governors. And my lady, when the order had been served on the 7th of December, the strike notice had already commenced. And my lady, therefore, I humbly beg that you review your order, taking into account what you presented before the court.
I've already taken 8 minutes of your time.
Yes, mine is brief. My lady, in quick rejoinder, on the question of whether parties have audience, my lady, this contempt has already been, you have already made your mind in regard to a sentence that has been passed. This is an application for review of that sentence. The effect of that is that they have already been punished, in the sense that you have already pronounced yourself in regard to whether they're in contempt or not, and what the punishment is. But further, my lady, there's been a question of the concurrent jurisdiction of this court and the Court of Appeal. Mr. Masese has sought to produce cases that do not reflect the situation in the current case. My lady, none of those cases concern a situation where contempt has already been punished. Both cases are at the advanced stage before punishment or contempt. And on the question of concurrent jurisdiction, my lady, we have a Court of Appeal decision from 1985. It is unreported. It is the case is Madhu Paper International Limited versus CAR. We would be providing copies of this.
Madhu Paper?
Madhu Paper International Limited versus CAR, K-E-R-R. My lady, this
Where is a
1985 decision, Kenya Law Reports. My lady, the essence of this decision is that the judges of the High Court and the Court of Appeal have concurrent jurisdiction, and the two courts have to exercise their jurisdiction. We will provide this to the court and also provide it to my colleagues as you retire to make a decision. My lady, finally, the Counsel for the Attorney General and the Counsel for Moi Teaching and Referral Hospital have inferred that the minutes were not signed, my lady, but they have failed to demonstrate through a replying affidavit or to counter those particular minutes through a replying affidavit. It would have been simple for the CS to simply swear an affidavit and say that this meeting never proceeded. No such replying affidavit is before you, my lady. So in essence, counsels are testifying from the bar and should not be allowed. That is all.
Can you allow me a minute? 1 minute. It will be 1 minute. Under the content of Court Act, the new Section 36 reads as follows: the provisions of this Act shall supersede any other written law relating to contempt of court. So, my lady, you can't refer to anything else, contrary to what the advice of government says in this regard. So, Section 37, my lady, there are no rules, yes. But more importantly, The provision for review is under section 32. The provision for appeal is under section 33. My lady, they say Parliament in its wisdom, for Parliament is forever wise, did not put a proviso in section 32. If Parliament intended that section 32 shall be subject to section 33 on appeal, my lady, nothing would have been easier than for Parliament to say so. It never did. And therefore, any submission to suggest that review of your order can go to the Court of Appeal, or